Welcome to Dare to Speak, difficult conversations that can change everything. This is a place for you to bring those difficult conversations that you've been mulling over, that you've been thinking about while you've been walking around, doing the washing up or commuting to work. I'm Stanway. I am a philosopher, psychotherapist of 25 years, divorce and breakup coach, and I help people in the moments where there's a difficult conversation they just don't know how to handle. This is a moment, your moment, to pause, reflect, and have a bit of breathing space to think about what matters to you and how to tackle those difficult moments. Using insight, reflection, case studies, and examples, I will guide you through those difficult conversations in a safe and constructive way. So let's begin. Hello and welcome to my Dare to Speak community video, where I bring experts on to talk about different aspects of divorce, separation and breakup that you might not think about or you may be aware of, but you would like to know a little bit more information about. And today I'm really delighted to invite Marcos Kallou from Prior Knowledge. Marcos is an award-winning estate planner and the nominated NHS will writer for Hertfordshire NHS Trust, with a wide experience of all aspects of wills, trusts, power of attorney, estate planning. And today we're going to be talking specifically around separation, divorce, dissolution of civil partnerships, and even a little bit, I think, about what happens where people think that they've got a common law marriage, where they're not married or in a civil partnership, and perhaps don't understand the situation. What happens if somebody becomes infirm, if somebody loses capacity, and if somebody needs to plan what happens to their estate, perhaps in relation to their next marriage, their next partnership, new children, and all of the complexities. So welcome today, Marcos.
Thank you. Thank you for having me.
Oh, you're very welcome. It's a real delight. We've been talking for quite some time about this, and it's good to be finally doing it. So I'm going to kind of dive in. Can you just give us a snapshot for people who don't really know? Perhaps they've never spoken to an estate planner. They think, oh, well, that must be for a big estate in the country. They don't realise it's specifically about our, what the wealth is we have within our own life, or what the property and so forth is. So can you explain a little bit about that?
Yes, thank you. So I get asked a lot the question, what is the difference between a will writer and an estate planner? And stating the obvious, a will writer is somebody who writes a will. So you go to somebody who say, I want you to write a will, and this is what I want in it. And they will write a will accordingly. Often online services are that kind of service. You tell them what it is and they just produce it for you. An estate planner, the end result of estate planner is, of course, a will. But the difference between an estate planner and a will writer is that a estate planner will ask you all those difficult questions. Why are you doing this? And what happens if? And it's to really understand the whole process. It's not just putting words down on a piece of paper. It's getting to understand, are we going to need to talk about tax? Are we going to need to talk about minor children? What happens if this happens? What happens if that happens? Why are you doing it in this way? So it suddenly becomes a whole conversation rather than just somebody saying to me, the obvious thing would be for me to say, I want to leave everything to my husband. The first question would be, why? Why do you want to leave it to your husband? And they will say, well, it's because it's my husband, it's obvious. Well, it's obvious, but it's not necessarily the right thing to do, because if you die and your husband remarries, what happens to the estate after that point? So it's about those kind of difficult questions. And I always say, clients say to me, Marcus, what I want is this. And I say, I don't give my clients what they want. I give them what they need. So when a client says, I want this, you may well want that, but actually what you need is something completely different. So we have a whole conversation around it.
Yeah. And that is so important because, nobody likes thinking about death. Nobody likes thinking about what happens afterwards. And technically speaking, you're not there yourself, but actually the impacts following a bereavement of managing the admin
Yeah.
are very, very complicated. And I always will say to people, like, the biggest gift that you can give is not to have to deal with massive administration as well as bereavement, because
Yeah.
it really adds layers, and especially around separation and divorce. And I know that with you, the difference with working is developing that relationship so that as things change, because you can go back and change a will, can't you? You can
Of
make
course.
alterations.
Absolutely.
And that's important it's important really, I think, to have the basic document in place and then make alterations rather than going, oh, exactly,
Yeah.
because it's a kind of working document to some extent, isn't it? In some ways. Yeah.
That's a big mistake people make is they make a will, they stick it in a drawer somewhere, and they don't review it for decades. And I
Yeah.
go see clients and they say, no, we only did our will 10 years ago, and they get it
Mm.
out and it's dated 1997.
Mm.
That's not 10 years ago. People forget the
They
passage of
forget
time.
when they do it.
So,
Yeah.
it should be, as you say, a working document that you review, look at maybe every 3 or 5 years. Doesn't necessarily mean you're going to change it, but a lot can
Mm.
happen in 3 or 5 years.
Okay.
You fall out with people have died or moved, or things have
Mm.
happened.
Things have happened. So if we just kind of go around aspects around separation, divorce, dissolution of civil partnerships, what are, if you had to kind of highlight, I don't know, 4 or 5 kind of specific issues that you see come up
Mm.
that it's useful to consider, what would they be?
So I think the probably the obvious one, and the one that I come across all the time, is the way that somebody owns a property.
Yes.
If you're dealing with a husband and wife, and going forward, when I talk about husband and wife, I also include civil partners,
Yeah.
because in law they are almost exactly the same. So the terms husband and wife or spouses will include both. When you have a husband and wife, invariably they will own the property together.
Yeah.
And they will own the property as what is known as joint tenants. There are two ways of owning property. The most common way, and the way that most conveyancing solicitors tend to favour, is joint tenants.
Mm.
And what that means is, on the death of one owner, the property will automatically pass to the survivor.
Yeah.
So on the face of it, you will say, well, that's what most clients would want, and that's the obvious
Yeah.
thing, and there's nothing wrong with joint tenants. And to an extent, you're correct. The problem is, though, is when you have a breakdown, people are worried. They say, well, if I die, my estate goes to my wife. We're going to be separated. She's going to move on and have start a new life. I don't want my share being left to my wife, who then remarries or meets someone else or buys another property with them, and my estate then becomes part of their new joint
Yeah.
estate. So one of the first things we need to do is we need to do what's called a severance of tenancy,
Yeah.
so that we sever the tenancy so that it's no longer held as joint tenants where both parties own the property 100% between them,
Yeah.
but it's owned as tenants in common 50-50. In
Yes.
that way, you can make a will that says, I want to deal with my share, my half, independently from my spouse or my ex-spouse. So that is something we do all the time. We do the severance of tenancy. It's a fairly simple form done at land registry. And then I see the client and say, right, you are now free to leave your share to your children. It doesn't pass automatically to your ex-spouse for them to then do with what they want to. So that's the sort of main obvious one. I think the other things to consider, clearly, breakdown of marriage. I always say that a life-changing event is a trigger for making a will or updating a will. Clearly, a divorce or separation is a life-changing event. So it's a good opportunity for you to review your finances, review your life insurance policies, because very often they pay out to a spouse as well. All of those things is part of the conversation as an estate planner we talk about, to make sure that your pensions and all of these things are dealt with, that your estate is dealt with. If you've got joint assets in a bank account, you might want to put them into separate bank accounts. So it's those kind of life-changing events. People, it's funny, when they get married, people are not so bothered about making a will necessarily, but my word, when they get separated, absolutely changing. I don't want my husband, I don't want my wife getting my money, yada. So it's a very important time to review these things and look at them.
I really think that that's true. And I mean, if I could change something, I would put the terms and conditions on the back of the marriage certificate, because really, when we're getting married, we are, with my worldly goods I thee endow, however it's phrased. Certainly, I mean, it's fairly similar actually across all countries, that, the automatic is that you're together in everything when you get married, but actually the positioning of the financials when you get divorced. People get divorced. The process of divorce is applying for a divorce, and we've now got a no-fault divorce, so you can just apply. And then there's a kind of waiting room of 20 weeks while you sort out the finances. And what people often don't know is the financial aspects, the legacy aspects, the trust for the children, stuff like that. Life insurance isn't weirdly part of the divorce. It's part of the financial arrangements around the divorce, which is a separate process, just like the child custody are. And that's where people can think, well, because they're married, they don't need a will because everything will automatically go to their spouse. But even that's not entirely true. And certainly if you're remarrying and you've got children from a previous relationship, there can be complexities there, because you're going to want to protect the inheritance for your children potentially, and so forth. So it becomes a bit of a compromise.
Yeah, no, and you're right. There's two areas else that we also look at. That is that one that people forget, and I come across this all the time, Eve, that people get divorced, but they don't get a final settlement order, a financial settlement order, and they think that, and they say to me, but I'm divorced, I've got a full and final, a decree absolute. And I say, yes, but that dissolves the marriage. It doesn't separate your finances. So although I'm not a family lawyer, I then have a conversation with them to say, right, you do realize, and people don't know this, that you do realize that if without a financial settlement order, even though you are legally and legitimately divorced, if one of those parties dies without having remarried, that's a key thing, they potentially still have a claim on the other one's estate. They don't know that. So
no, they don't know that. And that means inheritances, parents passing and money coming in, winning the lottery, with what people say.
Yeah.
There's a potentiality, even if the claim isn't successful, the grief and annoyance of defending it can be really, really difficult to have to deal with. And a fairly simple will and conversation can save you that potential trouble.
One of the potential dangers of DIY wills, I'm sort of digressing into an area that's not really my expertise, but a potential danger is clearly people think that they can do an online divorce and it's done and finalized, but they forget the really important part, which are the finances. And on the topic of finances, another thing to remember when you divorce is that as a married couple, your inheritance tax thresholds are doubled. So you get your spouses, you get your civil partners. So as a married couple, if you've got children, if you add your two allowances together, you've got £1 million. Suddenly, and if you're married and one partner dies, you've still got £1 million. But the moment you divorce, you then become a single person, and suddenly your whole outlook on inheritance tax may change, because suddenly now you haven't got £1 million allowance, you've only got 500,000, which could be quite significant in the great scheme of things. So that's another conversation that we need to have, to look at, and as an estate planner, I look at the estate as a whole. And it's not just about words on a paper. It's about looking at the estate as a whole. How is your estate constructed? How is it made up of? Have you got IHT friendly investments, or are they all in a bank account, which isn't particularly IHT friendly? So it's all those kind of conversations that we have with people, and a lot of those, particularly the one about the financial settlement order, they just don't know about.
No, and it is a extraordinary knowledge gap, which causes untold conflict when I'm working and coaching people through settlement, because they're not, every relationship pretty much has got a disparity of income. Every relationship, there will be somebody who came with more money into, or a property or something like that. And also because of, the increases in house prices, there's an awful lot more people who have fallen into the inheritance tax bracket that would not have conceived of themselves as being that, while they're sitting there going, oh, my house has put on all that value, but they're not there. There's a thing. And can I know it's kind of even more complicated, but people who think, to be really clear, a common law marriage is not a thing. It doesn't exist. So sometimes, and very often, you have people and they live together, they've got children together, they've developed a life together. Wills, estate planning, and trusts in those situations, honestly, in terms of if somebody passes and you haven't got a will, that's very complicated. But when separation takes place, that can be monumentally complicated, because the divorce and breakup process, which people may complain about because it's complicated and vaguely very annoying sometimes, you don't have any of that with the common law situation. Like this, what have you got? So how does that, what happens there with
Yeah, it's a great fallacy, actually, because I come across this quite often. People say, oh, we're common law. Common law as a legal thing hasn't existed for about 200 years. It doesn't exist. There is no such thing as common law husband and wife. You either are married or you're in a civil partnership, or if you live together, then the law, forget how you see yourself, but the law sees you purely as boyfriend and girlfriend. You could have lived together for 20 years, you could have children together. But if the relationship is not formalized, you cannot fall back and say, but we are common law husband and common law wife, because it doesn't exist as a concept. So the situation is slightly different on death than it is if you split up. But when I see clients who are living together, I always say to them, and to be honest, I don't always do it, but I always say to them, you need to be considering doing a cohabitation agreement.
Yes.
Not always legally binding, but at least it's something, because if you were to split up, they're arguing about who are the CDs belong to, who does the dog belong to. It's these kind of things. They sound trivial, but there are things that people fall out over. If you are living together and one of you dies, you have to be mindful of the fact that you do not exist in law. You can't fall back on this thing and say, I am I'm a common law husband or common law. It doesn't exist. So people who live together have to take particular care with doing things. And the other thing is, we talked earlier about inheritance tax. All of the inheritance tax legislation is about people who are married or in civil partners. People don't realize that if one of you dies, there may be an inheritance tax bill on first death. When you're married or when you're civil partners, any inheritance tax is delayed until second death. Whether it's £1 or £1,000,000, it's paid on second death. When you are living together, you're just cohabitees. One of you dies, if that person, so let's say you and I were living together, I'm worth more than the threshold. I die, you then have an immediate tax bill of whatever 40% is of my estate over and above the threshold. It's immediate. And
so what that means is the estate has to pay, which means that the person who's passed away, their estate has to pay, and that tax bill is collectible, i.e. the property that person part-owned with you will need to be sold potentially to pay that bill. And that doesn't matter that you're living there and you've got kids and stuff like that.
Doesn't matter. If I die and we're living together and there's £100,000 tax bill, the taxman will say to you, Eve, there is £100,000 £100,000 tax bill,
Yeah.
which somebody needs to pay. You
Yeah.
as the executor, it's your responsibility to pay it.
Yeah.
How you pay it, couldn't care less. And if
Yeah.
that means selling the house and whatever. So
Yeah.
these are really important conversations that people don't
Mm.
realize, that when you are living together, not married, not
Yeah.
civil partners, there could be an inheritance tax bill on first death, and then another bigger inheritance tax bill on second death.
Second. Gosh.
So it's a
And,
real, and people don't realize that.
and I think it's really worth kind of emphasizing that wills and estate planning is, you know, the truth of the matter is that when you write a will, you won't be round. Typically, you're not going to be around to see what happens. So whether or not you write the will or don't write the will, you're not going to be there. So you're not going to be paying that tax bill. You're not going to be able to help or support the person that you love while they're going through this, because you won't be there. That's the particular thing. But understanding this does make a massive difference. So I think one of the things can be really difficult, and this is where the difficult conversations come in, saying to somebody, I love you very much, but we need to look at what would happen if one or other of us dies to protect ourselves, protect the children. That can feel like a hard conversation. And I'm going to imagine that because I know you visit your clients, you do as much as possible face to face. Actually raising that, let's talk about what happens if you die, can be complicated for people because they think maybe they're being selfish, maybe they're being money grabbing, maybe they're being unkind. But it's a big thing, isn't it?
One of the biggest barriers, I guess, when I talk to people about this is they say, oh, well, it doesn't matter. I trust my husband. I trust my wife.
Yeah.
That they'll do the right thing. They won't exclude the children. And actually, Eve, it doesn't come down to trust at all. Trust has got nothing to do with it. It's circumstance. Your spouse remarries. That doesn't mean you don't trust them, but they've remarried.
Yeah.
That changes the dynamics suddenly.
It does.
Your surviving spouse ends up in a care home. That doesn't mean you don't trust them, but the dynamics have changed and they've ended up in a care home. They've inherited from their deceased partner. Suddenly their estate is now worth twice as much as it was. Potentially that money is then going to be used to pay for their care home.
Yeah.
So trust actually doesn't come into it when people say, no, but I trust. It's about circumstances. You don't have a guarantee that if you die and then when your partner dies, that the children will inherit, because circumstances, life gets in the way, things change.
Exactly that. And so having these conversations, these are some of the hardest conversations, but understanding that following separation and divorce, having these conversations to set up wills. So if we look at this kind of constructively, because there are some very constructive outcomes. You have a couple who are separating and actually it's all heartbreaking and it's sad, but they try and do it in an amicable and well-behaved way, which people do. Okay. In those situations, estate planning, wills, powers of attorneys, trusts, things like that mean that, and I've experienced this with quite a number of couples, they will separate, they go through the divorce, they sort out their financial arrangements, they do all of that, but then they're in a position where they will sit down and then do some estate planning. And estate planning is when they're going to sit there together and go, right, well, we're going to write wills that support our child and support what we do if we get in future relationships and have other kids and stuff like that. But that we like each other still after the process enough that we can be executors, or we can have that guardianships, or what those trusts are. There's a whole area of cooperation and collaboration that can be done around wills and estate planning. I think people have an idea that it's always going to be difficult. There's in fact a whole load of very positive stuff, isn't there, about planning
there is
things to happen.
having done this for over 22 years now, I know the number of clients who actually find the whole process really cathartic.
Yeah.
Whether they're married, whether they're single, whether they're in a separation situation, they actually find the process cathartic because it gives them peace of mind. It gives them the knowledge that things will happen as they want it to happen.
Yes.
We use it as an opportunity to look at things holistically. So suddenly they say, "Oh yes, I've been meaning to do that for a while," and they use that as an opportunity to get something else in their life sorted out as well. So I get great pleasure when, at the end of the day, we're talking about a fairly somber subject. But when people go away, they say, "Thank you, Marcus. I found that really positive and beneficial, and you've taken a load off my mind." It can be, or should be, a very positive outcome, positive process.
I would definitely agree. And having, you were kind enough to help me doing my own will, and there's a great sense of peace because you know that it's done. And my daughter did, my son, I think it was my daughter. She said, she found where I put it. I haven't put it put it where you could find it. And she said, I've read through. Yep, that sounds all right. I mean, she's only young, but knowing that is there, knowing that they're able to have a look through, knowing that you're able to have those conversations. Having recently lost my dad, who didn't put a will in place, and it did cause difficulty because those conversations weren't had. So there's a different view about what he wanted. They can feel. I always say that on the other side of every single difficult conversation, there's a much better place. There's a place of connection and relationship and collaboration, because these conversations do bring people closer, sorting out powers of attorney, working out what people are going to want, even little things about where their jewelry might go or what gifts somebody might want to make.
Yeah.
They bring a lot of peace and connection and reconciliation and understanding, actually, don't they, when they're done well?
They do. There was a case, quite a famous case within the profession last year, and it centered around an Asian couple. The wife had died, and then the husband had died. And the two siblings, as a brother and a sister, one of them was convinced that the father had wanted to be buried in the UK. The other one, the sister, I think it was convinced. She'd had a conversation with her father saying that he wanted to go back to India. Now, the siblings were arguing, not because they weren't arguing over money. No. They were arguing because from the position that the brother was saying, "I am adamant Dad wanted to be buried here with wife."
Yeah.
And she was saying, "No, we had a conversation and he told me he wanted to go back to India to be buried there." That's what they were arguing about. And it went to court. Yeah. And ultimately, it cost a lot of money, and the judge had to make a decision based on no evidence, based on what he says and what I say, because it wasn't written down. There's no mention of it in the will. These conversations took place with the brother and the sister, but they didn't take place together. And there was a complete misunderstanding. And the judge said, "This is one of the saddest cases I've come across, because you are clearly a loving family and you want to do the best by your parents as you believed this is what they wanted." In the end, the judge found in favor of the son, but based on no evidence, based on the fact that the wife was buried here. So he said, "Look, it's reasonable that the father would want to be buried here as well."
But for the want of a sentence written down with a signature and a witness, that would have been dealt with. And that's something that we see happening a lot. And that's why, when I work sometimes, it sounds mad as a divorce coach, but I work with newly married couples and couples who are getting married and who want to make sure that the communication, they want to avoid divorce. There's so many people who've been raised in broken homes that they want to, when they get married, not get divorced. It's a really sensible thing, I think.
Yeah.
And I will often talk to them about estate planning, about looking at power of attorney, looking at stuff like that. And they will often look at me, "But we don't need that till we're old." And I'm like, well, no, you need it now. It's worth thinking about these things now. It's worth looking at the financials. It's worth looking if you've got an inheritance that you're expecting or happens because somebody passes away. It's worth talking to your estate planner about what you want to do with that inheritance, you know, where you want it to go, how you want it to be divvied out. Maybe you do want it to go and pay some of the mortgage off, but if you were to get divorced or something were to happen, what do you want? And managing all of that, having these difficult conversations, really by having these now, you're saving a difficult conversation in the future, aren't you?
Yeah.
That you
Indeed.
won't be there to participate in, perhaps.
Mm.
Can you just, for people who don't understand necessarily or they're not aware, because I've referenced powers of attorney as well,
Yeah.
which isn't in your list, but is another really important aspect of the work that you do and in terms of estate planning, isn't it?
It is, yes. So basically, people say to me, what are they? I've got a will while being a power of attorney. So the will deals with your affairs when you die. That's what it is. It's a set of instructions that says, when I die, this is what happens.
Yeah.
A power of attorney is to deal with lifetime. What happens if you are hit by a bus, you have a stroke, you get Alzheimer's, suddenly something happens suddenly.
Yeah.
So you're still alive,
Yes.
but you haven't got capacity. And one of the biggest fallacies that people fall into is they say, well, I'm married, I don't need, because my wife will do it for me. Well, actually, that's incorrect. Why is it incorrect? Well, first of all, if you've got a joint bank account, a joint bank account works on the presumption that each of you gives the other one consent to use it. This is how the banks look at it. If you have no longer got capacity, you can no longer presume that the other person has consent.
Yes.
So the banks, they don't always do it, admittedly, but they are supposed to. It's in the British Bankers Association guidelines that says when you have a joint bank account, if one of the party, doesn't matter if there's 4 or 5 or 2 people on the bank account, if one of the party loses capacity, you, Mr. Bank, are supposed to suspend the bank account.
Yeah.
Because the person without capacity can no longer give consent.
Yeah.
People don't know that.
No.
Secondly, even if you are married, if you need to speak to my pension people, or the utilities are all in my name, or the Sky TV is in my name, and you ring up and say, can I do this and can I do that? They say to you, do they not? We need to speak to the account holder.
Yes, exactly.
Very sorry, he's in a coma. And they say, well, without his consent, without her consent, we can't speak to you. You are the wife, you are the husband, but you don't have power to speak on their behalf. And the big case in this, people can Google it, was Kate Galloway, when her husband, Derek, got COVID right at the very beginning of it all.
Yeah.
She'd been on public record. The car was stolen. The car was in his name. She couldn't get a crime reference number. Therefore, she couldn't make a claim. They had a joint mortgage. The mortgage came up for renewal. Joint mortgage needs 2 signatures. Derek was unable to sign for anything, so she couldn't renew the mortgage. This is why she was on public record saying that she was £700,000 in debt. So do not fall into the trap of thinking because you're married or because you've got a joint bank account or if you own the house together that you don't need a power of attorney. The house together is a really big one. If you and I own a house together, even I lose capacity, and you want to sell the house to pay for my care or to pay for medical costs, how do you sell the house? It needs 2 signatures.
You can't. Yeah, exactly. So, and that is, and so these are the crucial areas that people aren't thinking about, but I know it really matters. And there's a difference between, so there are 2 types of powers of attorney. There's finance and property, which operates and works slightly differently from health and welfare.
Correct.
And they operate slightly differently because I know that with the finance one, you can, if you are somebody's power of attorney, they can ask you to, even when they've got capacity, they can ask you to, sit in with a conversation at the bank or something like that. But that's not the case with the health. It's not quite the same, is it?
No.
Yeah. And I would say the other thing, and I remember being, I think this is accurate, but I remember being told that for the health and well-being one, being a power of attorney gives you a lot more say in what happens. And one of the things that happens with a lot of the do not resuscitates in COVID was without the power of attorney, people only had to be informed what would happen.
Correct.
They weren't consulted on what would happen. Is that right?
That's exactly right, Eve. And COVID was a good example of this. Lots of things were happening. People didn't have powers of attorney and they were losing the opportunity to make decisions.
Yeah.
The biggest story I tell clients, and it's not COVID related, but this is a true story, it was reported by the BBC. There was a man, he was a police officer. He was married. He got knocked off his motorbike in a collision and was in a vegetative state.
Yeah.
His wife, and I stress that, his wife did not have a power of attorney.
Yeah.
And it took her, it's all in the public domain, it took her 18 months, a year and a half, to go to court to get permission to switch off the machine because...
How sad.
And it's all, as I say, it's all in the public domain.
Yeah.
She was his legal spouse. They were husband and wife.
Yeah,
but because she had no power of attorney, the doctor said, no, we are going to keep him going. And she said, no, even if he survives, he doesn't want to be in a vegetative state.
Yeah.
18 months, Eve, of the stress of everything to have to go to court to switch off your own husband's machine. She got permission, so switched the machine off and he died about a week later. And they were married.
Yeah. So I suppose what we're kind of highlighting here today, and, you know, anybody kind of listening to this and watching this is just a little dive into some really very complicated areas. And they're probably areas that you've heard people talking about in terms of, somebody died and, how do we do probate and these types of things. And I suppose what people don't often think is, actually, this is stuff that in a quite cost effective, because it's not expensive, you know, we can resolve or we can prepare for some of these issues as an act of kindness, as an act of love, as an act of intention and care for our family, for our children, for things, because money causes so many arguments and misinterpretation of people's wishes, the need to act but not necessarily being able to, it can really add to the sense of grief and shock and unfairness, because we don't understand what the law is until we need it, and then we go, it's got structures, but if we haven't put the structure in place, the law doesn't work for people who haven't done these things. Does it? You know,
No,
supports you if you have done a power of attorney, but if you haven't done one, it looks bizarre.
It's an awful position to be in. You then have to apply for deputyship, which is, anybody that's done it just say it's a horrendous process, very expensive. It takes a lot of time. You're looking at a year plus, very stressful. And you said something that's making me smile, actually. I have clients that say to me, oh, Marcus, you know, we've spoken to our children and our children have said to us, you know, we don't want your money when you die, mum and dad. And I say to them, yes, that may be the case. This is what they're going to say to you when you're alive. They're not going to say to you, mum, don't spend the money. I want you to give me as much as possible. They're not going to say that. They'll say that to your face when you're alive. But my word, once somebody dies, suddenly they say, oh, mum didn't leave me any money. Why didn't mum leave me any money? So, you know, you just need to be careful sometimes of what people tell you to your face. Of course, nobody's going to say to you, I want you to die and leave me all your money as much as possible.
Well, yeah. I mean, again, as you said, it's situation and circumstance. But it's also, that's still not a good reason for not doing a will or not thinking about what happens. Because say your kids are like, no, we don't want any money. If you haven't decided what happens to your money, then either they're going to get the money and they don't want it, or they're going to be in grief and in confusion. So estate planning is taking responsibility for your own estate, and these things are not expensive to do. Wills, my recommendation is to use a professional will writer such as yourself, because although people can write it down on a piece of paper, somebody with the experience to actually be able to do what you said at the top of this, which is ask the questions, is really important. I hope that people listening to this can see that this is complicated, but it's much less complicated to do it now than it is to try and work out how to resolve what hasn't got done later.
Correct.
And these are difficult conversations, but they're also redeeming conversations. They are beneficial conversations to have because they allow people to have clarity, and usually it's lack of clarity that causes stress, and that causes arguments, and it does cause family fallout. So Marcos, if somebody wanted to, they've listened to this and they think, right, actually, I need to start looking at this. What is their next best steps? How can they contact you? What should they do?
So you can see behind me my web address.
Yes.
So it's tryknowledge.co.uk. If you just type in Try Knowledge Wills, if you can't remember that, it will come up. I've got a website. They can email me. They can contact me. My telephone numbers are there. Although I have an office in Epping, I actually, as you know, I have an office also in Skipton in North Yorkshire.
Yeah.
So I cover the whole of the country. So, I'm based in Epping and people ring me up and say, I live in Cheshunt. Is that too far for you to come? Well, no, it's not, because I got clients in Yorkshire and Manchester and all over.
Yes.
So just call the number, Google me, and say just Try Knowledge Wills or Try Knowledge Epping, something like that, or Try Knowledge Skipton. And I'll come up and contact me via the website or by telephone.
And I'll put all the details in the show notes for this anyway.
Thank you.
And, if this is something that you are listening to and you're thinking, oh gosh, I'm worried about, I really need to talk to my mum or my dad, or I really need to talk to my partner about this, and you're feeling hesitation with beginning these conversations, I think what I would say is, yes, this is a difficult conversation. So you can go and also have a look at my website and we can, jump on a call and talk about how you tackle it. But these are difficult conversations that can be life-changing because at the moment your life changes, you're going to know what it is that's in place and what you need. The tools that you need will be there when you need them, because wills do last, powers of attorney continue to last. I know what you said about them getting outdated, but at least it's better to have something, even if it's outdated, than it is to have nothing, because the legal framework is just really difficult, isn't it, to deal with. So, Marcos, thank you so much for your time.
Thank you. It's my pleasure.
I really appreciate you coming on and talking about this. I think we'll probably have to get you back on to keep talking about this.
I'd love to. Thank you.
And I'm going to also encourage anybody watching this, if you've got any questions, if you want to reach out to Marcos, if there's anything that's kind of been raised here that it would be useful for us to elaborate on, or you want some kind of individual advice on, please get in touch. Because this is a conversation that it's worth having, and it's worth starting it now. My children are 24 and 19, and I've already got powers of attorney in place. I've already got things in place, because I want the children to know that there's something really good about taking responsibility for this stuff yourself and demonstrating through leadership. That's what we do.
Yeah.
So thank you so much for your time today, Marcos. I look forward to chatting to you again.
Thank you.
Take care.
Thank you. Cheerio.
Bye-bye.